So the topic is judgment and sentencing. So we'll just run them down the way they come. The question is, when does a court give judgment? Judgment is given at the end of the criminal trial. At the end of the criminal trial, the judge, magistrate, depending on which court is trying the matter, will fix a date for the delivery of judgment. Now, before talking about the rules guiding judgment, what we want to look at now is, what is judgment? What is judgment? The judgment is the final pronouncement of the court in respect of a criminal litigation. Final pronouncement of a court in respect of a criminal litigation, deciding whether the defendant has been found guilty or not. That is the final pronouncement. And once this pronouncement is made, the court loses jurisdiction to do any further things as a general rule. Once a court gives judgment, it becomes what we call functus officio. It cannot dot an I or cross a T, because the duty of that court in respect of that criminal trial has come to conclusion. So that's why we call it the final pronouncement. And talking about judgment, there is no particular style of writing of judgment that is recommended or required. In other words, every judge has his own pattern of writing judgment. Like, for instance, somebody like me who is equally a poet, I like reading judgment that are poetic. You know, those flowery, the judgment that flow, that is flowery. Talking about judgments of Kayode Esho, Oputa, C.C. Nweze, and so many of them. Nemeka Aguje, I see them was. Right, what I'm trying to illustrate here is the pattern of writing. Pattern of writing is peculiar to a particular judge. So there is no rule that says you must do it this way, you must do it that way. A judge chooses his language, so long as he doesn't cross the line. What do I mean by crossing the line? He doesn't show himself as being directly into the arena of the conflict. But then, there are some basic requirements of a sound judgment, things that a judgment must contain. For instance, we're talking about criminal litigation here now. When a judge is writing his judgment, the parties will be mentioned. The introduction or preamble the judge will have to show what the charge or charges before him were. And after stating the charges for which the defendant or defendants stood trial, the judge will talk about the brief or summary of the facts, the way he has understood the summary of the facts. Let's say, for instance, the first count has to deal with murder, that A killed somebody, unlawfully killed someone, which amounts to murder under the law. And then the summary, because when you just say that he kills, that thing has not given you, that very statement hasn't given you a full fact or deep insight into what actually happened, right? So for that, a judge may want to state the summary, brief summary of the facts of the case. For instance, maybe they were having issues over a particular thing, a fight ensued, and this person got angry and hit the other person. Whatever the facts are, It will be instructional that the judgment contains the fact. And now after that, there is something called evaluation of evidence. Either you call it evaluation or appraisal of evidence of witnesses, you're talking of the same thing. So the judge will now begin to analyze the evidence that we are given before him, starting from the prosecution. When the prosecution gives evidence, what does it want to achieve? The prosecution wants to know the defendant or defendants, want to show that the defendant or defendants committed the offense being charged. And they are bringing relevant witnesses. Mind you, under the law, there is no number of witnesses that is required for a prosecution to secure conviction. Rather, the prosecution is duty bound to go for their relevant witnesses. Right. So, the prosecution may not also want to bring in witnesses that will come and start contradicting themselves. Why? Because the standard of proof is what? Proof beyond reasonable doubt. So my Lord now starts to evaluate the evidence of the prosecution witnesses serially and in seriety. PW1 was one Mr. Okeke. His evidence is, he gives a summary of the evidence that Okeke gave in court in order to substantiate the charge that A and B committed the offense. Now, in doing such an appraisal, there are two basic perspectives of doing it. My Lord can, at the same time that he's evaluating the evidence of Mr. Okeke, he can also tell us what happened during cross-examination. But if he likes, he can state the evidence of all the witnesses on one part and then come back again to tell us how they fared during cross-examination. Are you following me? So any of the styles, it depends on the judge, and there is nothing wrong with adopting the style. But when a judge wants to adopt the style of, first of all, portraying the evidence given by each of the witnesses for the prosecution, that of the defense, and then come back again to talk about what he thinks of each of them, it is discovered that that judgment is bound to be a bit more lengthy. Are you listening to me? It's going to be lengthier because you are handling a particular witness 2 times. That's why I said it depends on his style. He can say, Mr. Okeke stated this, but upon cross-examination, he said blah, 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 blah. And then later he talks about his observation, the judge's observation. Whether there was contradiction, what kind of contradiction? Were the contradictions made on fundamental issues that will affect the case of the prosecution? He will also point it out. Right. So after analyzing this, he also analyze the evidence of the defense. That the defendant or defendants and their witnesses, if any, how they also fared during cross-examination and his observation. And then having said that, you're now having the whole fulcrum of the facts of the case before you. The next thing will be to apply the law. And that moves into the next thing, which is what? Issue or issues for determination. So the court draws out possibly or probably the parties in the final written addresses of their counsel would have raised issues for this determination. My Lord is not bound to adopt the issues propounded by parties where he feels that those issues so propounded are not helpful or have not covered the ground. So nothing stops a court from formulating its own issue for determination. Provided that if the issue formulated by my Lord is totally alien to the parties, like a deviation of the case they have presented, my Lord must do what? Must ask the parties to address him on any issue he has raised suo motu. But if the issue is not particularly raised suo motu, but the kind of a marriage of issues raised by the parties, my Lord may not be obligated, he won't be obligated to call the parties to address him on that. And now, after all these things are done, you are now looking at the judgment of my Lord. He goes straight to his findings. That findings will be coupled with observations. What is observation? What is the difference between findings and observation? Findings are what you actually see, what transpired. That is the result of your evaluation. Those results of your evaluation are your findings. But on the other hand, observation may be when the defendant was giving evidence, you are watching the demeanor of the defendant. It could be the defendant while giving evidence was prevaricating. It could be that maybe he was being evasive in answering questions. All those things, the court is noticing. The court will also do what? Note it in the judgment. If he feels that it is germane to the writing of his judgment. But some of the times too, that could be misleading, because if somebody's facial expression is not properly interpreted, it means that you will do what? You put him in jeopardy. Because if my Lord overstretch the issue of the matter, he may end up violating the presumption of innocence of the defendant. Because there are people who naturally who by nature may have a facial expression that is different from their thoughts. Am I right? Yes, facial expression that you can easily do what? Misinterpret. Right. So it will be wrong to strictly judge a defendant by the way he looks during cross-examination or how he behaves. Except we can say maybe that kind of behavior is generally not acceptable, or a kind of behavior that portrays foolhardiness. You are asked a question, it's a different thing that you are thinking to get an answer. And it's also a different thing that you don't want to answer that question, or you just want to deceive the court. Do you understand? But then, we should also have to draw the line between standing mute, right, or silence, because it's constitutional. They are statutory. Right, so the point I'm making here is that the manner counts, but it's a dangerous thing. It's dangerous. Now, after the judgment has been written, the next will be to pronounce it. Why is that judgment pronounced? It must be pronounced in the open court. So there is nothing like a judge pronouncing judgment in chambers, except maybe when he thinks that public policy supports that, safety, his security supports delivering it in the chambers. But the general rule that he must do what? Deliver the judgment in the open court. Or maybe when an infant is involved, he needs to pronounce judgment concerning an infant. Two ways of doing it. Either he may want to do it in chambers, or he may excuse the presence of the infant, keep the infant somewhere, and then use a pseudonym for the infant. Not calling the real name of the infant, XYZ, ABC, right? So that you don't even know who he's talking about. That is the only time my Lord can give judgment in the open. When it concerns an infant, right? Or somebody who is under age. Now, having noted that judgment has to be pronounced in open court, the next thing is that what is the time frame? What is the time frame for pronouncing that judgment? From the conclusion of trial to the pronouncement of judgment. The rule is guided by the Constitution itself, which means it has to be a period of time that must be taken seriously. So it is sacrosanct the way it looks, but I can tell you the rule is that a court must give its judgment within 90 days of conclusion of the final address. That's a question of the final address, because that's when the matter has ended. But we have to remember that judges are human beings. We also have to remember that they have a lot of things to do. They have a lot of duties to discharge. Does it mean that if the judgment is delivered after 90 days, it becomes invalid? The answer is no, both in the past and now. Before the amended constitution, 1999 amended constitution, the rule used to be, if anybody is challenging a judgment on the ground that it was not delivered within 90 days as prescribed by the constitution, the person must show that he has suffered miscarriage of justice. That he has suffered miscarriage of justice by virtue of the fact that that judgment was not delivered within 90 days. And that leads us to the question of what is miscarriage of justice. What is miscarriage of justice? If judgment is not delivered within 90 days, it simply means the effect. What effect does it have on the defendant? And the effect here is not like an emotional effect. Because if the judgment was given a week after 90 days, was there a compliance? There was no compliance. But the next test would be, was there miscarriage of justice? Miscarriage of justice, he who alleges has the burden of what? The proof. So if you are saying that you suffered miscarriage of justice because it was not delivered within 90 days, you have to show it. Now let's do a bit of exercise. What miscarriage of justice can you think of? Put yourself, now let me not say you are the defender, you are the defense counsel, now you are the defendant's counsel. Judgment has been delivered after, let's say, instead of 90 days, let's say 120 days now. So let's hear from different persons. What would you think may be miscarriage of justice that kind of judgment may rot? Aja has not said there is any offense for which you should not stand your trial. Under the CPA, any day the accused person was absent, the matter will just be what? It will be adjourned. It will not go on. But under Aja now, absence for 2 days means that the magistrate or judge can do what? Can proceed. I've taught this in the class. So it's not like maybe there is any, that means you're taking the court for granted. Your own convenience is now overriding the convenience of the state. You know we are talking about state here. We are talking about the interest of state. So that visa is secondary as far as that trial is concerned. Once you are standing trial, your liberty is what? It's restricted within the purview of the law. So forget about medical things. Now you discover from this exercise, you see now that it is even difficult for you to ordinarily show miscarriage of justice. Right. Now, but miscarriage of justice can come in several ways. One, if the delay so much affected the mind of the court that the court forgot vital issues of the trial, that would definitely lead to miscarriage of justice. Maybe when the court forgets that there was somebody who testified as per your alibi, and because the matter has been so delayed before judgment was given, the judge forgot. So that would be miscarriage of justice. Then too, an inordinate delay may be such that when my Lord is appraising the parties, my Lord misplaces onus of proof. It's a very serious thing. If the delay so much affected the mind of the court that during appraisal of evidence, my Lord misplaced onus of proof as between these two persons. If somebody has asserted, and my Lord said, it's you that would have proven it, but because you failed, the judgment will be, or the ruling on that issue will be against him. Ordinarily, it should not. My Lord arrived at that erroneous decision. Why? Because he misplaced the onus of proof. Those are miscarriages that can cause miscarriage of justice. Miscarriage of justice must be within the fulcrum of the law and the trial. it doesn't have to do with your personal things you want to do. That this trial, no. The trial has to take preeminence before every other thing that concerns you. So when you say the trial delayed me, it denied me of a contract, you're talking to yourself, because it is the law first. So any mistake made by the judge as a result of that delay will be a trade to find out whether it resulted into a fundamental error, either error of law or error of fact. And when that happens, we say that there is what? Miscarriage of justice. And now, even under this 1999 Constitution, it is discovered that a particular provision there talks about the 90 days rule, and then later say that nothing shall invalidate the judgment simply because my Lord has blah blah blah. He said there is what? Miscarriage of justice. What amounts to miscarriage of justice is not a fanciful thing. It has to be what? Very, very substantial. All right. Question? Okay.
For clarity's sake, can right lead to miscarriage of justice?
Now he's talking of a different thing. We are talking about judgment outside 90 days. Who will tell me what he's talking about now? Who will tell me what he's talking about? You're almost lawyers now. You should be able to contribute. How do you categorize what he's talking about under the law? What will you call that one? Which one the official court? Are you African politics has killed you? It's a different part. What will you call it? Under what will you bring it? Bias. Not fair hearing. Somebody was ahead, but there was bias. Rules of natural justice. There was bias. When the judge shouldn't have sat over the matter at all. Because the fact that it was compromised, you can prove it to mean that there was one bias. So that's a different scenario from what we are talking about. We are talking about the delay in delivering judgment. Now let's say after the judgment, during the pronunciation of the judgment, my Lord is faced with about 5 defendants in a matter. Different counts, maybe there are counts linking them together, but it's the same transaction. Conspiracy, other things, remember. So, if during pronunciation of the judgment there are so many defendants, a different rule applies. The rule that applies is that the judgment pertaining to each of the defendants must be read straight. It's one judgment, but the pronouncement on the whole of them must be defendant per defendant. You cannot say, a court cannot say, I find the 5 defendants guilty as charged. That's wrong. That alone can vitiate the judgment. A judge must be able to tie the role of defendant A to count 1. Has count 1, has he been found guilty in respect of count 1? And the reasons. If the answer is what reasons support, what operated in your mind to convince you that the defendant was guilty as charged in count 1? After handling him, you come to defendant number 2. Defendant number 2 may not be guilty on the same count that what A had already been convicted for, or he may also be convicted for that. But the point is that there is nothing like lumping up or pronouncement. That pronouncement must be clear enough to tell us what each person did and the resultant consequence of the role of each of the defendants. It's a different thing if it's only one defendant is being tried. And my Lord will just go, I find the evidence against you very strong enough. You could not debunk, blah, 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 blah. And then in the end, I'm convinced in my mind that the defendant committed the offense. Or he said this, and the evidence was corroborated by B. So to that effect, defendant could not debunk either the evidence of A or the corroborative evidence of B. Therefore, I'm convinced in my mind that A or the defendant committed the offense. So that's how a judgment should run through. And when a defendant is found guilty, or the defendants, as I have explained now, found guilty in the end, what follows next? What follows next is plea of mercy. That plea of mercy is called what? Allocutus. It's called what is allocutus and what is the effect of allocutus? Allocutus, does it reduce the gravity of the offense? Does it affect the judgment? If the allocutus is reasonable, if it provides insight into why my Lord should not exercise maximum punishment, then my Lord can come a little bit lower. If my Lord cannot convict for the highest offense, my Lord can also convict for what? For the lower offense. Or in sentencing, come lower than the maximum. If, for instance, it's an offense that has an option of fine, the allocutus can explain why this person has been a good person. He's not, at this stage, he's not saying he didn't do it, because he has been found to have done it. He has served the nation, he has done. Allocutus we may consider, that is when the person will start telling of his good deeds. That's when he can start talking about his good character. It's different from character evidence. What I have done, what I am, so at least I deserve mercy of the court. Maybe I did this inadvertently. Even though ignorance of the law is no excuse. But I was ignorant of the law. I thought I was doing it. There's something somebody will do that will look right, but in the end, it's an offense. Are you following me? Yes. And the person will say, I didn't know, but though ignorance of the law is not. If, for instance, it's supposed to be 8 months imprisonment, my Lord will say, okay, I'll give you 5 months. Or if it's something that has option of fine, my Lord will say, okay, go and pay the fine. Or in the alternative, do community service if it's simple offense. Community service as punishment is not given in all cases. By the time I look at briefly types of sentencing, we'll talk about that. Now, if all the defendants have been convicted, have been found guilty, each of them will also plead what? Allocutus. Nothing stops a counsel from pleading allocutus for the client. Are you following me? You as counsel for the defendant can plead allocutus for the defendant. Because at times, the defendant may be so traumatized by that pronouncement of guilt that he can't even talk. If you ever see this in life, maybe some people at times, they will just cry and cry, especially in capital offense. So we have looked at allocutus, we looked at the 90 days rule and the exception. And then we'll also talk about reading the judgment to the open court. Okay.
There is allocutus, same with plea bargaining.
No. Plea bargaining simply means you don't want the trial to go on. You're pleading guilty, but on a bargain. Plea bargain reduces the rate of the offense and there is no trial. Or the trial stops at the point where the plea bargain is made. Right, sentencing. Now, after the allocutus, the next thing will be sentencing. Some judges may sentence on the same day that the allocutus was made. Some may adjourn to consider sentencing, to take that allocutus in mind, so that it will now affect their mind when they are sentencing the defendant. Sentencing simply means the process of apportioning punishment. I put it punishment in quote. Although under criminology, they don't want to use the word punishment, but punishment remains what? Punishment. They will tell you that somebody is, most of the time sent to prison in order to reform him to rehabilitate him, this, that, and that. But the point is that who follows up? Because at times you see somebody who comes out of prison, the next thing he goes back again. And that's why most of the times when the police are investigating a particular crime, they look for people who have committed that kind of offense and they are now free. They will say, boy, come and provide evidence. A good number of them are police informants, right? And being police informant doesn't mean that they have been reformed any bit. Now, in sentencing or that in apportioning punishment, there are several types of punishment a court may give. We have mentioned something like community service in simple offenses or misdemeanor. We'll talk about fines and prison sentence. Some of the time, prison sentence goes alone, just prison sentence, no option of fine. Some of the times too, you see some laws prescribing prison sentence and option of fine, or both. One can be sent to prison and also made to do what? To pay fine. It depends on, most of the time, gravity of the offense, and most of the time, the conduct of the defendant also determine the kind of punishment that he is given. Then we also have flogging, but in the north, their own is called hardy lashing. So, and there are rules for this hardy lashing and the kind of cane that should be employed and where the flogging would be done. Maybe at times on the bare back, at times on the buttock, depending on what that very particular law has said. Now, in prison sentence, terms of prison, imprisonment, if the law has prescribed maybe for 10 months, nothing stops the judge from sentencing for a lower term of imprisonment, but he has no jurisdiction to sentence for higher than what is prescribed by law. When one of the group members was talking, she made that mistake of saying that the judge can neither go low nor high. No, the judge can go high, but the judge can come low. Right. But there are also some laws that we prescribe mandatorily, that when somebody is convicted, the person must go in for, let's say for instance, 7 years. So when the word employed is mandatory, then there is no discretion. So what you do is to look at the letters of the word, of the law, to find out if the court reserves any discretion in the punishment. But where the court doesn't reserve any discretion, then the court goes for the mandatory punishment. And one other thing we need to know is, in prison terms, let's say for instance, somebody has been found guilty, and the sentencing for count 1 is 7 months. Sentencing for count 2 is 12 months. Sentencing for count 3 is 13 months. For count 4 is 2 months. How would this thing run? Is the punishment to run concurrently or consecutively? Most of the times, especially by our law, the punishment runs what? Concurrently. In other words, you don't serve 7 months, and then after you go and serve 11, and then after you go and serve 13. And concurrently means you are serving the highest one. Are you following me? Count 1 7 months, count 3 8 months, count 3 12 months. So if you total them, you're getting like 27, but instead of 27, you're serving what? 12 months. Because 12 months is the highest one. Within 12 is 7. Within 12 is 8. That is why it is called what? Concurrent running of the terms of imprisonment. So another thing we also need to know here is, when somebody has been sentenced, whether it's running concurrently or just a single term of imprisonment, When does time start to run? When does time start to run? Is it at the day of conviction or the day he's taken to prison? Any opinion? What? The day of conviction. Any other contribution?
The day he was taken to custody.
The day?
He was taken to custody.
The day he was arraigned. Why? Because that was the day officially his liberty was what? Restrained. So if he has stood trial for 12 months, or for let's say for 11 months, and has been sentenced to 12 months, how long will he serve now? So that's how it is calculated.
Supposing the defender was on administrative bail.
It doesn't matter. What matters is the date of arraignment.
How about if the trial has exceeded the highest term for prison? Like maybe say the trial has exceeded 12 months and 21
If the trial lasted longer than the punishment, you let him go, he has served. Do you now see why most of the time there is this workshop trying to make sure that we will have criminal litigation reformation? Do you now see why AJA was enacted? It's because of this type of a thing. And do you also realize why Witness Protection Act was promulgated? It's also because of this. But the one that I don't know the state now is the issue of compensation. Somebody who has stood trial and in the end, the punishment ought to be 12 months, he has stayed there for 5 years. Will he just go home like that? Is he not entitled to something? That's what the workshop had been trying to talk about. In other words, they try to see what information can be done along that line.
Okay, sir. What if the accused,
The defendant.
the defendant, jumped bail? Let's say in the instance of Section 352 of the Act, he jumped bail and his trial went on in his absence. And then later on, he was
caught.
And brought to court. Now, with his presence of absence,
The court cannot exceed the maximum punishment. That's just what should be in the mind of the court. He has done something wrong, but you know what some judges do, or courts do. When that happens and he's caught and the matter has not ended, you revoke his bail, put him in the prison. He will be coming from the prison to stand trial. Do you understand? You cannot, because he jumped bail and the maximum punishment is 10 months, say, okay, I'm giving you 15 months. You cannot. You won't have jurisdiction to do that. Why are we interested in criminal law? Go ahead.
Okay, sir. You said a judge cannot give a sentence that is beyond what the law says. What of, for example, the punishment for robbery? We say the wording of the law is shall not be convicted for less than 21 years. Does it mean that he can?
The 21 years is there as the limit now. We are saying you cannot exceed. Do you understand? Any letter put there, you cannot exceed. Now, let me give you an instance where somebody exceeded. Danny for me against Ayorinde. These are judges, I think Ayorinde, Honorable Ayorinde was either sitting in the Keja division there. So Ganifa me made a comment, which the judge found to be contemptuous of his person. So Ganifa was convicted. Maximum sentence for that offense was 3 months. But Ayorinde gave him 6 months. Does it mean the judge didn't know? Or was he having a temper issue? Do you understand? But that was how the man is kept. So Court of Appeal set it aside because the punishment exceeded the prescribed maximum. And then they begin to also check how long the trial took. Once Lord Dennis said that if you don't have a jurisdiction, you cannot even dot an I. It's just like putting something upon it will collapse, not fall. It will collapse. All right. You can see it. But let's just talk about two more things. Death sentence in capital offenses. When the sentence for a particular offense is death, that is capital offense, the judge comes to court dressing in a different apparel. So he must wear a red gown instead of a black gown. So that signifies that what is involved is capital offense. The fact that he's wearing red doesn't mean that the man must be convicted though. Right. But the point is that in most cases, when they wear red, in most cases, the person gets convicted. But that's the attire for giving judgment in respect of capital offenses. So it's just symbolizing danger, something happening. When a person is sentenced to death, now that we no longer have the firearm tribunal, like the one that prescribed for death by firing squad, and bearing in mind that capital punishment in most cases in the whole world are trying to be, removed, abolished, so that we'll have life sentence. But when a judge pronounces death sentence by hanging, there is a prescribed word that the judge must use. But it doesn't mean that any slight deviation from the usage of that word will invalidate the trial. No. Something like, you, Mr. ABCD, you are hereby found guilty and charged for the death of so person. I hereby sentence you, because it's the day of sentencing, I hereby sentence you to death by hanging until you die. May God have mercy on your soul. He's going to die, and they're also praying for him. And say you'll be hung on the neck until you die. So that is why, like especially in Malaysia and some other Asian countries that practice that, even when the person at a particular point in time, after the struggle and the struggle ceases, they'll bring a medical expert to find out whether the person has actually died. They wait for some time. They must ensure that he has died. They must ensure that he has died before you can now say, yes, this person has been. I will take your question. Then, in some other jurisdictions where you have the lethal injection, somebody has committed the essence of lethal injection was a kind of way to ameliorate death by the guillotine. We still remember how many of us here did history? How many of us? Okay. So that's when they devised this process of lethal injection. That's poison. You hit the person by poison, and then it's also a soft way of killing as against electric chair death. Electric chair. And because we discovered that in America in the time past, a good number of those who were killed by that process, electric chair, were later found to be innocent. And they were mostly, they were mostly niggers. Do you understand? So, and then they now say, okay, let's stop this, let's do it in such a way. And in killing the person during the death chamber, the family will be admitted. Why on earth would I want to come to witness somebody who is going to die? Now, when does this punishment take place? When is death sentence carried out? When is death sentence carried out? So this is the last point here now to make. Death sentence is carried out only when the governor assents to it. And you discover that every governor who doesn't, who was not there when it happened, maybe was just elected, and they want him to sign for somebody to die. They will just wash up their hands. Most of them will never do it. But that duty is actually incumbent on them because the crime was against the state. The crime was against the state. But there are some people or some governors that say, to hell, go ahead, bring this in, let me sign. And they will sign. And they will sign. And then if you had, let's say for instance, you have a client who has been so convicted, and you are asked to seek for a remedy for him, what will you do? The immediate thing that should come to your mind is what? To apply for prerogative of mercy. So you apply for prerogative of mercy.